rights are being violated, the fact that the very fundamental justice no longer hold any kind of importance in our trial. So we definitely wanted to begin this conversation at an important time like this. Wanted to talk about due process and its value and why it means, why it has its position in place within the criminal justice system. With that very, very quick context, I'd like to invite Rebecca John ma'am to kindly take stage. As all of us know, Rebecca John is a senior advocate at the Delhi High Court, so she will be our first speaker. Before I hand the stage over to her, I just want to let you know that the format of today's discussion will be each speaker will get about 20 to 25 minutes to present their thoughts. And after both speakers have addressed us, we will have a round of questions. And both our panelists have expressed their wish to keep this more interactive than just a monologue. So we encourage you to actively write, put all your questions in the chat so that we can pose them to the panelists. Ma'am, over to you.
Thank you, Purva. Thank you very much for inviting me for this webinar. Since the time is the time limit has been fixed, so I'm going to be reading largely from a written script, but I will deviate as and when I think it's necessary. On the 27th of November 2019, a veterinary doctor left her clinic situated at Gachibauli on the outskirts of Hyderabad. On the morning of 28th November 2019, the Hyderabad police recovered her burnt body from an underpass near Chattanpalli on the Hyderabad-Bangalore highway, nearly 25 kilometers away from her last location. On 29th November 2019, the police arrested 4 lorry drivers and cleaners between the ages of 20 to 24 for the offenses of gang rape and murder. High voltage public outrage followed and 3 policemen were suspended for the delay in registration of the FIR. On December 4th, the police sought and were granted 7 days police custody by the first additional district and sessions judge in Mehboob-Nagar for the purpose of interrogating the accused and collecting evidence based on such interrogation. In the meanwhile, their names and photographs were splashed across digital media and the print media. Public opinion had already pronounced them guilty. On the morning of 6th December 2019, the country woke up to the news that all 4 accused had been killed in an encounter under a bridge on the Hyderabad-Bangalore highway while they were in police custody, triggering a chorus of praise for the Hyderabad police, as many saw it as speedy justice. The brazen choreography of events can be captured here. 4 suspects, unarmed and in police custody, taken by 10 armed policemen around midnight to the spot where the doctor had been raped and killed. The 4 suspects were not handcuffed, and the police sought to impose an unbelievably naive narrative on an unquestioning public that the men had grabbed their firearms and were therefore killed in self-defense. Not only was the police theory bizarre and implausible, but the summary execution of the 4 suspects was celebrated by many as a victory of good over evil. What happened with the doctor was an unconscionable crime. The police utterly failed in its duty to secure her most basic fundamental right, to be safe on the street. But this tragic trail and its equally tragic ending failed us in many other ways. By not sending the 4 men to trial, and by not allowing the evidence collected against them to be tested in a court of law, the Hyderabad police failed us all. Because it is now impossible for anyone to conclusively establish that the men the police chose to arrest and demonize were the men who had actually committed the crime. What about the men themselves? Is it so difficult to imagine that they were not guilty of the crime, but were simply picked up to satisfy a bloodthirsty mob? What justice was served on the night intervening 5th and 6th December 2019 when they were killed in cold blood? And what if there was indeed evidence to suggest that they were guilty of gang raping and murdering the young doctor? Who gave the police the right to employ medieval mob justice tactics and shoot them? What happens to the sacred principle enshrined in Article 21 of the Constitution, which states that no person shall be deprived of his life or personal liberty except according to procedure established by law? Their guilt or innocence had to be established by a court of law. The denial of a trial was as much injustice to the accused as it was injustice to the victim, and indeed to society as a whole. In the name of the victim, the call to due process and the established norms of free and fair trial, which is the sine qua non of Article 21, the state decided to play God. The value of due process cannot be emphasized better through another example. Between January and March 2020, we faced a raging debate in this country. When it was asked, would the 4 men guilty of the brutal rape and murder of a young woman in Delhi in December 2012 be hanged? The jurisprudence in India has always leaned towards Article 21 protections, even to death row convicts. Some of the commonly asked questions on acrimonious television debates were, why must the president look into the mercy plea filed by a death row prisoner? And for what reason is a prisoner given 14 days after the rejection of his mercy plea by the president? When will justice be served? What about the rights of the victim? With respect to the presidential powers of mercy enshrined in Article 72 of the Constitution, it is important to revisit the judgment of the Supreme Court in Kehar Singh versus Union of India and another, involving the assassination of a sitting prime minister. That even after the final adjudication of guilt of an individual by the judicial process, the framers of the Constitution considered it necessary to add an extra safeguard, almost like a safety valve, by giving the president an affirmative power to grant mercy. It is open to the president to exercise that power vested in him under Article 72 of the Constitution to scrutinize the evidence on record of the criminal case and come to a conclusion different from that recorded by the court. He acts under a constitutional power, the nature of which is entirely different from the judicial power under which the court acts. Why is the minimum period of 14 days given to a death row convict between the date of rejection of his mercy petition and the scheduled date of execution? In Shatrughan Chauhan and another versus Union of India, a 2014 judgment of the Supreme Court, the court enunciated the following principles. A period of 14 days must be given to a death row convict after the rejection of his mercy petition to allow him to prepare himself mentally for execution and settle his earthly affairs. It also allows the prisoner to have a last and final meeting with his family members. The Supreme Court held Article 21 inheres a right in every prisoner till his last breath, and this court will protect that right even if the noose is being tied on the condemned prisoner's neck. Powerful words. So these are the cherished ideals of our Constitution, where even a death row prisoner is entitled to Article 21 and due process protections. And the same has been recognized, not only by the Indian Constitution, but by courts. Nowhere is due process and constitutional guarantees more important than in the journey, the ordinary journey of a criminal trial. We all know that Article 21 states that no person shall be deprived of his life or liberty except according to procedure established by law. Arrest is the most fundamental curtailment of the liberty of an individual. Which right is guaranteed to that individual under Article 21 of the Constitution of India, and the same can only be taken away in accordance with procedure established by law. Section 41 of the Code of Criminal Procedure confers wide powers on the police to arrest an accused for the commission of a cognizable offense without obtaining a warrant of arrest from the concerned magistrate. However, no such powers are given to the police with respect to non-cognizable offenses. Since arrest is one of the most coercive steps the state is authorized to take against citizens, numerous safeguards exist in the statute to prevent the arbitrary exercise of this power by the police. Section 50 mandates that a person arrested has to be informed of her grounds of arrest and she has a right to legal representation. The framers of the Constitution considered it such an important guarantee that they enshrined it as a fundamental right in the Constitution under Article 22(1). Under the law, no person can be denied the right to legal representation. Section 41D now allows an accused person to ask for a lawyer of his or her choice during interrogation. Section 41B mandates that that the minute a person is arrested, the police must inform immediate family members or other persons connected with the accused. When can an arrest be made? Arrest involves the complete, and as I said, complete and utter curtailment of liberty of an accused. Since it's such a coercive measure, it must not be used unless there is no other option by the investigating agency. The division bench of the Delhi High Court, in a case titled Court on its Own Motion versus State, Criminal Reference 4 of 2017, thought it important to highlight that arrest should always be avoided if the investigation can be completed even otherwise, and the accused gives full cooperation in completion of investigation. And it went on to say that arrest may be necessary if the offense alleged is of a grave nature and prescribes severe punishment, and there's a likelihood of an offender either absconding or not appearing on being summoned or fleeing away from justice. In Arnesh Kumar versus State of Bihar, the Supreme Court had occasion to look at another provision of recent introduction, Section 41A of the Code of Criminal Procedure. And the Supreme Court said that for offenses punishable with less than 7 years, it was important that the police do not effect the arrest in the first place. The Supreme Court said, and I quote, "Our endeavor in this judgment is to ensure that police officers do not arrest accused unnecessarily and magistrates do not authorize detention casually and mechanically. Notice of appearance in terms of Section 41A of the Code of Criminal Procedure must be served on the accused within 2 weeks from the date of institution of the case, which may be extended by the Superintendent of Police of the district for reasons to be recorded in writing." The underlying spirit of this judgment was that for cases which are not heinous in nature, that is, cases that are not punishable with life or death, the police ought not to exercise its powers of arrest, even if it's available to them, and must try and follow the mandate of Section 41A of the Code of Criminal Procedure. This judgment was again followed by the Supreme Court in another judgment called Dr. Rini Johar, and another was the State of Maharashtra, and it pretty much endorsed the findings of the Supreme Court in Arnesh Kumar's case. It is therefore abundantly clear that compliance with Section 41A of the Code of Criminal Procedure is necessary in those cases where the punishment is not of a serious kind, before the police arrest an accused person. And the rampant abuse of power of arrest has been deprecated by the Supreme Court in this judgment. In fact, the Supreme Court has said, and I quote, "Arrest brings humiliation, curtails freedom, and casts scars forever. Lawmakers know it, as also the police. There is a battle between lawmakers and the police, and it seems that the police has not learned its lesson, the lesson implicit and embodied in the CRPC. It has not come out of its colonial image despite 6 decades of independence. It is largely considered as a tool of harassment, oppression, and surely not considered a friend of the public. The need for caution in exercising the drastic power of arrest has been emphasized time and again by courts, but has not yielded result yet. Power to arrest greatly contributes to the arrogance as also the failure of the magistracy to check it," unquote. What are the procedures that are available to an accused person who is arrested by the police without a warrant and then has to face the criminal justice system? The Code of Criminal Procedure, as also the Constitution of India, makes it clear that within 24 hours of arrest, an accused person must be produced before a magistrate. As per the original scheme of the code, investigations should have been completed within the first 24 hours. Of course, since then, there have been various amendments to the code. And Section 167 authorizes the police to produce the accused before a magistrate within 24 hours of the arrest. And in case they have not completed investigation, they can seek remand of the accused for further periods of time. Section 167 makes it clear that such remands will be taken in tranches of 15 days each. And during the first 15 days, the police has the right to ask for police custody remand. In fact, the first 15 days is often referred to as the interchangeable custody remand period, where an accused can be sent to judicial custody and then to police custody and back to judicial custody, or in whichever order the police wishes to enforce the right to take remand. However, remand must be justified. And time and again, the Supreme Court has cautioned magistrates that do not remand mechanically. Look at the case diaries. See whether the accused is even has remotely committed the crime. See the nature of investigation and come to a decision whether remand of the accused is necessary or not. Even police custody remand is often discouraged, as you would have seen in Anupam Kulkarni's judgment, where the Supreme Court said that the police has to make out a case for police custody remand, and it is not routine and it is not a right they have, although they can make out that case in the first 15-day period. Therefore, the magistrates who authorize remand of an accused person must see whether that remand is justified or not. Indeed, there is a judgment of the Delhi High Court which says that when an accused is produced for remand, parallelly, the same accused person can move an application for bail. Because if you oppose remand, and if bail is granted, then there is no question of remanding the accused to further custody. So these two go hand in hand. It is often seen that remands are mechanically given by magistrates on the asking of the investigating agency. Now, both the rules and orders of the High Court, I can speak for the Delhi High Court rules and orders, as well as the statute, as well as judgments of the Supreme Court, make it clear that the magistrate remanding an accused must insist on signing case diaries. Because when they sign case diaries, then it becomes evident that they have applied their mind to the facts and circumstances of the case, and they feel there is a need to either grant remand or extend remand of the accused person. The point I'm trying to make is, very often, remands in our country is given mechanically because magistrates who are overworked perhaps do not care to look at case diaries, do not engage in a conversation with either the accused or the prosecutor, and mechanically extend remands of accused persons. This is a practice which must be deprecated. In a case that I recently, well, not that recently considering we've been in lockdown for a while, but in a case that I recently advised in, it was found, I noticed when I was being briefed that all the offenses for which the accused were charged were bailable offenses. And yet the accused had suffered remand of more than 7 days through orders of court. Now, in bailable offenses, the police does not have the right to arrest, and the police can certainly not produce that person before court asking for remand. And the magistrate can certainly not grant remand in these circumstances. The FIR very, very clearly noted that the offenses for which the accused was charged preliminarily were all bailable offenses, and yet the accused persons suffered custody for 7 days till it was brought to the notice of the court. So these are the kind of due process violations that take place routinely, perhaps not that often in big cities, but certainly routinely in the far corners of our country. And we must therefore be conscious of the fact that the police may ask for remand when there are no reasons justifying the same. And therefore, we must compel magistrates to look at case diaries, to look at the facts and circumstances of the case, and insist upon their signing every page of the case diary so that there's no interpolation subsequently. These are rights that are enshrined in the Constitution. These are rights given to accused persons by the statute, and defense counsels must be conscious of these rights when they represent accused persons. After the stage of 57, coming to the stage of 167, where periodical remands of 15 days at a stretch are given, and the Code of Criminal Procedure says that depending on an offense or the case that is being tried, the maximum period of remand is either 60 days or 90 days, as the case may be. And within that period, the police must complete its investigation. What is the rationale behind this time limit? The rationale is that no person can be kept in custody indefinitely. You have to complete your investigation within 60 or 90 days, as the case may be. And if you do not complete your investigation within the statutory time limit, the accused is entitled to statutory bail. The consequences of not completing an investigation has to be borne by the investigating agency. Now, in several cases that are coming up now, where UAPA is sought to be imposed on accused persons, as you know, UAPA, hypothetically, the investigating agency has a right to take custody of an accused for a total period of 180 days, beyond 90 days, that is. It can take 90 plus 90 days if the court so agrees to its request. This has now become routinized. It has now become the norm. It is no longer the exception. The minute the police invokes UAPA, it believes it has the right to custody up to 180 days. And we need to challenge this because the Criminal Procedure Code, indeed even the UAPA, as draconian as it may be, expects the police to complete investigation within 90 days. And the additional period should and can be invoked only in very, very exceptional circumstances after the prosecutor, through his report, has convinced the court that there are compelling reasons to do so. But does it happen in that manner? Or has this become the norm? Unfortunately, the events of the last few months, maybe the last couple of years, makes me to believe that this has become very routine. The minute UAPA is invoked, it is as if the police gets a fresh lease of life. They get 90 more days of custody to slowly complete their investigation. This should be frowned upon. Why? Because what you're doing is extending the period of detention of an accused person. He has rights at the end of 90 days. By extending it to 180 days, you are circumventing the rights available under the Code of Criminal Procedure, Section 167. But this practice has now become the norm, and it appears that courts are not looking seriously into applications and reports moved by public prosecutors under 43D2 of the UAPA, and are allowing extensions without examining the material before them and without coming to the conclusion that the extension is sought for compelling reasons. as I said, the Supreme Court has time and again said that the power to grant remand or extend the period of custody given to a magistrate must not be exercised mechanically. The Supreme Court has said, and I quote, "The act of directing remand of an accused is fundamentally a judicial function. The magistrate does not act in an executive capacity while ordering the detention of an accused. While exercising this judicial act, it is obligatory on the part of the magistrate to satisfy himself whether the materials placed before him justify such a remand, or put it differently, whether there exist reasonable grounds to commit the accused to custody and extend his remand." At a time like this, when courts are virtually not functioning physically, but we are appearing in the Supreme Court and in the High Court through an online process, how difficult is it to adhere to Article 21 requirements? As a practitioner of law and as a practitioner of criminal law, I recognize the multiple levels at which rights of the accused have been trampled with during this period. You may not believe it, but most remands today are taking place in jail, where duty magistrates are routinely remanding accused persons to further custody. What this means is that the counsel for the accused is not allowed to come to jail to oppose remand. They are stopped from physically appearing in jail and opposing remand, even if they want to. So this seriously compromises the rights of an accused person. Even during investigation, while the accused is in the custody of the police, the right of an accused person to get a lawyer of his choice to be present at least partly during the period of investigation has been trampled upon. In the large majority of cases that I'm dealing with now, I see that there is no record of the various remands that the magistrate has, remand orders that the magistrate has passed. There is absolutely no connection or interface between an accused person and his lawyer. He is unable to communicate to his lawyer whether or not statements have been obtained from him under duress. What are his rights when it comes to giving handwriting samples, giving voice recordings, his voice sample? None of this is possible because there is no interface between the accused and his counsel. It has been a long-standing demand of the bar with the various courts that you should allow video conferencing facilities between an accused in jail and counsel, so that at least the counsel can give his client legal advice. At what stage can you give your voice sample? Should you resist an application moved seeking your voice sample? Can you give your handwriting? Can the police take it as a matter of right? Is it possible for the police to ask you to give your password when it comes to your phone? Can they seize your phone and that of your family members? This conversation is not happening between the defense and a person who is in custody, thereby trampling on his most basic fundamental rights. So what is happening is there's a field day as far as the police is concerned. They continue to arrest, they continue to remand people to custody, and there is absolutely no interaction, except the formal interactions we have in courts when we move applications. But there is very little interaction between accused persons in custody and their lawyers. It can perhaps be said that that's the nature of the times that we are living in. After all, there is a health pandemic which is playing out, and possibly it's very difficult for courts to allow large number of lawyers to be present at the time when remands take place, which is why the Delhi bar at least has been insisting that remands should take place through video conferencing so that we can challenge the remand itself and we can bring essential facts and law to the notice of the court. These challenges are very important as we go ahead and face prosecutions, face trials. And unless those challenges are made at the right time, it will come back to bite the accused at a later stage. In 1981, the Supreme Court in a case called Khatri versus State of Bihar, which was otherwise called the Bhagalpur blindings case, said, and I quote, "It is clear from the particulars supplied by the state from the records of the various judicial magistrates dealing with the blinded prisoners from time to time, that neither at a time when the blinded prisoners were produced for the first time before the judicial magistrate, nor at a time when the remand orders were passed, was any legal representation available to most of the blinded prisoners. The records of the judicial magistrate show that no legal representation was provided to the blinded prisoners because none of them asked for it, nor did the judicial magistrates inquire from the blinded prisoners produced before them, either initially or at the time of remand, whether they wanted any legal representation at state cost. The only excuse for not providing legal representation to the blinded prisoners at the cost of the state was that none of the blinded prisoners asked for it." And unquote. What does this mean? Does an accused know his rights at the time when he's arrested? Is it not obligatory on the court to tell him that these are your rights? Instead, we have situations where if the accused does not demand it, the courts also close their eyes to the very fundamental right that exists, and people are remanded without legal representation. I will conclude by quoting from two recent judgments of the Delhi High Court. One with respect to the rights of the police to extract confessional statements implicating an accused person. By confessional statements, I don't mean statements under sections 25 to 27 of the Indian Evidence Act, but statements which incriminate an accused person. Until such time that that extraction is not made, they come to court and say that the accused has not cooperated with the investigation. The Delhi High Court had occasion to look at this in the context of the protected rights of an accused person and came to this conclusion. It's very interesting. The court says that while the state argues that the applicant has not cooperated in the investigation, the only aspect cited is that the applicant did not give to the IO original documents relating to the sale of goods against which money was received. However, this demand of the IO must be taken as answered on point of fact when the original signed office copies were delivered by the applicant's counsel to the IO in court as recorded in order dated 27/9/2017 made by the Sessions Court. The IO's allegation that the applicant was not cooperating in the investigation also needs to be put in legal perspective. Is the IO saying that the accused should be taken to be not cooperating in the investigation till he furnishes all materials that the IO thinks is necessary to nail the accused? We must remember that under our system of criminal jurisprudence, an accused has a right to silence, apart from a fundamental right against self-incrimination under Article 20, Subclause 3 of the Constitution. What would happen if an accused says that no other material is available, whereas the IO thinks or says that other material exists and must be delivered before the accused is granted bail? In such a case, would the court be persuaded to keep an accused in judicial custody endlessly till this impasse is resolved? Consider another scenario. What if an accused wants to produce some exculpatory evidence in his defense during trial and fears that if the exculpatory material is shared with the investigating officer during investigation, the investigating officer may either not produce such material before the court or destroy it so that it is not available to the accused for his defense? While in theory, it is the duty of the investigating officer to collect all evidence, whether inculpatory or exculpatory, during an investigation and to place it before the court, it would be naive for a court to assume that this theory is put into practice by investigating agencies. It is also well within the rights of an accused to bring out defense evidence only during trial. This is one of the reasons why, in a criminal trial, an accused is not required to furnish a written statement of his defense, nor to file any affidavit disclosing the evidence he proposes to adduce during trial. While in a civil trial, it is permissible to spring such a surprise on an opposing party, there is no such bar on an accused in a criminal trial. The investigation officer, therefore, cannot be heard to say that till the applicant hands over to him every shred of evidence which the IO thinks exists, the applicant should be kept in prison as an under trial. And then the court ends it beautifully by saying that the criminal investigation is not a metaphorical fishing rod handed to an investigating agency to indulge its penchant for fishing around for evidence at its own leisure and in the fullness of time. Investigation has to be time-limited process to be conducted strictly within the structure and framework of the Criminal Procedure Code. And in yet another judgment of the Delhi High Court recently, in an oft-used argument of the state that granting a bail at an early stage will send out an adverse signal, adverse message to society. And you can change this dialogue to different stages of the case, where they say, if you acquit the man, you're sending a different, a very, very strange message to society. If you are not going to hang the man, again, you're not sending out the correct message to society, the court held. This court is of the view that that cannot be the basis for denying bail. If the court is otherwise convinced that no purpose in aid of investigation and prosecution will be served by keeping the accused in judicial custody. Prison is primarily for punishing convicts, not for detaining under trials in order to send any message to society. The remit of the court is to dispense justice in accordance with law, not to send messages to society. It is this sentiment whereby the state demands that under trials be kept in prison inordinately without any purpose that leads to overcrowding of jails and leaves under trials with the inevitable impression that they are being punished even before trial and therefore being treated unfairly by the system. If at the end of a protracted trial, the prosecution is unable to bring home guilt, the state cannot give back to the accused the years of valuable life lost in prison. Justice Khanna, and I'll end with this. Justice Khanna in the iconic ADM Jabalpur judgment had said that the history of personal liberty we must bear in mind is largely the history of insistence upon procedure. I'll add, the history of personal liberty we must bear in mind is largely the history of insistence upon procedure and due process. Thank you.
Ma'am, thank you so much. I think the points that have come out here really is the fact that we've revisited all the basic principles in the Constitution, and we've seen and heard from somebody close to the action how due process is being violated at multiple levels, so much so that prisoners don't have access to legal counsels of their choice, that courts aren't applying their minds while looking into applications filed by their lawyers, all of which will eventually go on to impact their trial in a very, very adverse manner, and that these prisoners are not being given a chance to put out their facts and put out their side of the story, in a sense also showing us that even the bare minimum that the law is supposed to afford to those who are arrested or those who are accused of crimes is not being met. And finally, of course, the gist of the entire talk that we've heard is that the criminal justice system is not necessarily something that is here to send out messages to the society, but is in fact to uphold what the Constitution says and the criminal code says. So we are very, very happy to have heard from someone close to the close to the real action, and it was very enriching to hear you, ma'am. Thank you so much. We're going to now have Kunal, who's going to be talking to us. Kunal Ambasta is an assistant professor of law at NLSIU Bangalore. So Kunal, over to you. I hope I've unmuted you.
Yes, you have. Can you hear me?
Yes, perfectly fine.
All right. All right. Thanks, Purna. I guess it's 5:43,
Yes,
so I should be done in around 20-25 minutes. If I'm exceeding time, let me know.
sure.
Thank you also for inviting me and having me here this evening. And it was an absolute pleasure to listen to Rebecca as well. And it's an honor to be on a panel with her. So thank you, Rebecca, also for your presentation. And I'll begin. I want to take and we've all benefited from what Rebecca has taken us through in the criminal justice process through specific details of what the law says and what happens in court and what is currently happening with, let's say, anti-terror laws like the UAPA, as well as with the pandemic enforced shutdown of courts, which has led to a lot of on-ground violations of rights. I want to take a slightly different perspective, which is something that I have been talking about and writing about recently as well, which is to look at the idea of due process in the Constitution and the criminal justice system, and looking at how the criminal justice system is being divided, not recently, but has been divided over some time in this arena of general and special criminal laws, and what effect that has on uh, due process of the accused and due process rights of the accused. And I'll take four specific instances where I will try to make a point about the effect of these special criminal laws as well. Right. So that's anything I say is generally my perspective. I'll welcome questions and disagreements also from the audience at the end when we take questions. The first thing that I want to address and I want to ask you and I want the audience to think about is, how do you think about general and special criminal laws? In my perspective, the way I look at it, I look at general criminal laws as being three, which is the Indian Penal Code, the Code of Criminal Procedure, and the Indian Evidence Act. Of course, the Indian Evidence Act applies both to civil as well as to criminal laws and criminal adjudication, but we are talking about its application in the criminal justice system. Why do I call these laws general? I call the Indian Penal Code a general criminal statute because it generally defines the principles of liability, the principles of criminal justice, as well as generally defines and punishes, creates offenses for a range of criminal activity. So if you look at the Indian Penal Code, it is meant to be an exhaustive kind of a statute which mentions offenses against property, offenses against the body, offenses against the state, offenses against justice, etc., etc. It also talks about general principles of criminal law like exceptions, justifications, etc. Principles of mens rea and causation are in the Indian Penal Code. Why do I call the CRPC a general statute? I call the CRPC a general statute because wherever you are in the criminal justice process, right from the stage of an FIR being lodged to arrest, remand, starting of a trial, filing of a charge sheet, framing of a charge, alteration of a charge, how the trial is to proceed, everything is mentioned in the CRPC as exhaustively as possible. This is not to say that these statutes are perfectly drafted. I am not suggesting that. I am only calling them general in that limited regard, right? So wherever an accused is in the criminal process, he has to find where the CRPC mentions that stage, and he will be able to determine what is going to happen to him, what can he do at this point of time, what should his lawyer do, what should the court do, etc. In that sense, I call these two statutes general. Now let's come to the special criminal laws. Now, in my mind, special criminal laws are created on two aspects. One is to say to us that a particular kind of crime is a special crime. Let's say money laundering. We are told that it might be a special crime. Terror. We are told by the state it's a special crime. Terror is different. IPC cannot handle terror, etc., etc. Child sexual abuse. We are told that a special law is needed. A POCSO is needed to handle that. So the first way in which a special law might be created is to create a specific class of offenses and say that this is not covered or it cannot be covered by general law, and therefore it must be covered by a special law. Another way in which this is done is also to say that there is a specific class of victims that needs to be protected, and therefore a special law needs to be created in this point, at this point of time. Now, there is a certain logic to the creation of special laws in India that I want, again, you guys to think over. And to my mind, it seems that, especially when we come to terror laws and special laws that are enacted to tackle terror, these laws are premised on a particular logic of national security, that we are told that these laws are needed for the protection of national security and national integrity, which is facing a unique challenge in the form of terror, right? Uh, a lot of times you will also see that terror laws come in immediately after a terrorist attack takes place. And this is a moment of social rupture where the public support for government measures to tackle terror is at its highest, generally speaking. So we are generally very ready to support the government in whatever it says it wants to do to stop this scourge of terror. So I'll give you an example. The UAPA was amended immediately after the Mumbai attacks on the Taj Hotel and at the terminus, the railway terminus, that the CST that happened. So in a moment of social rupture where support for tough measures against terror is at its highest peak, that's when you'll see these special laws coming in. The logic that these laws come in following is that this is needed because the kind of threat that is being faced is very special. We never really sit back and talk about what is it about terror that makes it so special that the IPC cannot cover it, that we need a special law. We buy into this logic that is given to us, and we buy into this understanding that we need a tough law, right? Now, this brings me to my second point. Exactly how is a terror law tougher, right? And let me proceed for the rest of my talk today with the example of terror laws, such as what used to be TADA and POTA and what now is UAPA at a central level. Uh, I want to ask you, why do you think and why do you accept that even if we are to say that TADA or UAPA is tougher law than the IPC, in what exact way is it tougher? How do you make that difference between the IPC and the UAPA? Now, for example, a terror offense is also the offense of waging war against the country or against the government, Section 121 of the IPC, and which is punishable by a sentence of death, right? Now, there cannot be a punishment in law that is higher than the sentence of death. So how can the UAPA be a tougher law over 121? And in fact, if you look at terror cases even today, you will see that every terrorist is also charged and accused of a terror offense is also charged under Section 121 of the IPC. So you're still using the general law. So then what is the additional value that you get by adding a special law such as the UAPA? And I really want uh, us to think about this, because this is the crux of the entire argument about due process and criminal justice. And my answer to this question is this, and you can disagree with this completely. My answer to this question is very simple, that special laws do not change the criminal law substantively. They are never brought to bring additional punishment. They are brought to tweak procedure. They are brought to destroy due process. They are brought using this particular instance in society to compromise on your due process rights. And that's the entire crux of what I want to say, is that there is, if you look at the UAPA closely, there is nothing substantively that it adds. Right? Apart from giving the prosecution and the government a lot of leeway in different ways, I can't go into all the ways today, but one can look at it to compromise on otherwise safeguarded procedural rights under Part 3 of the Constitution. And I'll give some examples. So, for example, Rebecca has also talked about this, and let me also speak about this for a little while, your right to bail, right? So, we were told as to how Section 167 of the CRPC, which is a general law which talks about the right to bail in a default sense. If the police or the investigating agency defaults in filing a charge sheet within 60 or 90 days, then bail is given as a matter of right. Of course, there are certain conditions that can be imposed. This period is extended by terror laws. Generally speaking, the UAPA does it as well. Not only that, the UAPA also extinguishes the right to or severely limits the right to bail if the judge is of the view, based on the police report, that a prima facie case is made out. As a result, what happens is that in a terror case, you have next to no chance of getting bail throughout the trial, throughout the time that you are an accused person. And this is a period that can extend to for many, many years. Now, what is bail when one looks at it in this sense? Bail is not a minor inconvenience or a minor right, but as Rebecca said, bail is a safeguarding of your right to liberty under Article 21. You cannot be interminably kept in custody if, let's say, the police does not file its charge sheet. And that would be a severe violation of your right. But that is precisely what special laws allow, or at least at any rate, you would all agree, make it easier for the prosecution to do. And we are seeing the results of this all around us, where the moment you invoke an act such as the UAPA, you realize that getting bail, in spite of there being no evidence or charge sheet not being filed for the longest periods of time, is absolutely impossible, right? We have seen this in Bhima Koregaon. We are seeing this in other cases across the country as well. Now, of course, this is a question of liberty. This is a question of presumption of innocence, which is what I mean when I talk about due process rights in a criminal justice sense. What is the point of getting your client acquitted after they have been denied bail consistently for the last 10 years and have served 10 years in prison, incarcerated already as an innocent under trial? Right? And that's what the special law allows you to do, which probably would have been much more difficult under the CRPC IPC regime. It's not that the special law is punishing this person at a higher level. It is just curtailing a due process, right? That's one example. The second example I want to talk about is that of reverse onus clauses, right? Now, reverse onus clauses are also there in the Indian Evidence Act. There's a chapter on burden of proof, and which talks about several reverse onus clauses or presumptions as well. Special laws take that particular presumption to the next level, right? Which is that they allow the prosecution, based on the proof of certain basic facts, to presume the commission of the offense. This is there in the POCSO, in the Protection of Children from Sexual Offences Act, Section 29, and Section 30. This is there in the UAPA as well, right? Now, essentially, we might think of this as a technical thing, right? But what this special instrument has allowed us to do is to curtail and to truncate trial, where not all facts need be proved by the prosecution anymore. It leads to the burden being shifted on the accused effectively to prove that they are innocent, right? That's one more example. The third example I want to talk about is the extrajudicial confession, right? Now, the UAPA does not have this, but both the TADA as well as the POTA did. And there are trials currently still underway under both these statutes across courts across the country, in different parts of the country. Now, again, to make my point about the general and special law distinction clear, if you are being prosecuted for an IPC offense in which the CRPC is applying and the Indian Evidence Act is applying, there is no way that a confession made to a police officer can be proved against you. It will be hit by Section 25. There is an exception to that within Section 27 of the Indian Evidence Act, which allows limited facts to be stated that are stated in a confessional statement to be proved despite 25. But we are not going into technical details. What it essentially does, the Indian Evidence Act does, is that it disincentivizes police officers from trying to record confessions. And Section 25 notably is a British statute of that time. And It does not require proof of torture, duress, threats, etc., to kick in. All it says is that a confession cannot be recorded by a police officer. It cannot be proved if it is recorded by a police officer. So what is the proper way of recording a confession? Take that accused person to a magistrate, follow the procedure, the onerous procedure under 164 of the CRPC, and get the confession recorded. Now, this is what is removed by certain special laws to make it easier for confessions to be recorded. Right? And the question again is, why is this in a special law? And the answer to that is that it allows you to truncate a very essential right of due process, which is a presumption of innocence, right? Which is there in Article 20, which says that you will not be coerced, you will not be forced to be a witness against yourself if you are an accused. Now, nobody has touched Article 20. That Article 20 is still there on the book, in the bare text of the Constitution. But through these special laws, what effectively happens is that that right is essentially taken away. If you look at most TADA cases, most POTA cases, you will find that all the prosecutions in those cases have proceeded on an extrajudicial confession that is recorded to by a police officer, which gives rise to a question as to what is so special about these terror cases that all these accused suddenly decide to spout confessions the moment they are arrested and kept in custody. You must also understand that what is happening is a simultaneous denial of bail, which means that you are kept in custody, and also the fact that the police can coerce you inside custody and get a confession. Right? There are certain safeguards even under those statutes, but those safeguards can be easily compromised. There are post facto safeguards, that is after the recording of the confession, there has to be a verification by a magistrate, etc. Not going into that in detail, but I hope that you can see the point of how special laws are impacting procedural rights of the accused. The last and the fourth example that I want to talk about is this new phenomenon that has sprouted up, and very little is written about it, very little is known about it. I hope that some of you will talk about it and will try to research about it, which is this peculiar practice of katti, as it is called colloquially in Delhi, and it is spreading across. It is happening in Karnataka and other places as well. That is happening in terror cases. It essentially happens thus, that a person is accused of a terror offense, is arrested, and is kept in custody. The trial starts, and the trial drags on. Witnesses don't come, and therefore there is an adjournment. There is no chance of getting bail. Ultimately, the accused ends up spending around 8 years to 10 years inside custody, and the trial is still continuing. He does not know whether he's going to get acquitted at the end of it or get convicted at the end of it, right? But he is thoroughly frustrated, he's thoroughly broken, and he has no will left in himself to fight anymore. What happens now is a very peculiar thing that has started, which is that suddenly you will see during these trials that the accused will file an application to change his plea. The plea that was recorded at the time charge was framed will suddenly be changed. Sometimes it happens that the accused will file a plea bargaining application. A plea bargaining application, as you might know, is not maintainable in cases such as this, which are punishable by more than 7 years of imprisonment. He will file that will get dismissed. If he files an application to change his plea, there seems to be some kind of an agreement that suddenly pops up in court, which is that he will be convicted, and whatever time he has served already as an under trial will be the punishment that he will be granted. So what happens at the end is that the accused gets convicted, he is released, the prosecution walks away with a conviction without having had the burden of proving any fact in court, really, and everything is settled. Now, you will find that certain prosecution agencies which specialize in terror investigation are tom-tomming their conviction rates as 90+%, etc., etc. What is not known in the public is that most of those confessions, or at least most of those convictions, or at least a substantive number of those convictions are happening by these particular methods. Now, where is trial? Where is your due process right of presumption of innocence? Where is this question of the prosecution bearing the burden? These are not substantive changes that special laws do. These are all compromises to due process rights. These are all violations of Article 20, 21, you name it, right? We have a sound constitutional jurisprudence which extols these rights and has said that we will always expand them. But in reality, when one comes at the enforcement of these rights and what is happening at the ground level, the situation might be quite different. All of this is facilitated by special laws, right? Which is why I always say that when you say that UAPA is amenable to misuse, and TADA was amenable to misuse, and POTA was amenable to misuse, you're right. What you're saying is correct. It is the right argument to make. But it is also an incomplete argument. These acts, these laws are also designed in such a way, right, that you don't need to abuse them actively. You don't need to misuse them. You only need to invoke them. And their invocation promises and it ensures and guarantees that due process rights will be curtailed, that due process rights will be violated. So you don't need to go hunting for political opponents. Of course, that also happens, right? Definitely happens. But these laws essentially become tools uh, for the violation of due process rights. In fact, you don't need anything more than a law which says that you will not be granted bail. What more abuse can there be? What more misuse are you talking about? This is something that is there built in the law. It's properly inside the law itself, right? So I always say that these laws are designed for abuse. They are not misused simply, but their very design, their very structure, and their very passage and enactment is meant for misuse and abuse, right? Now, some of you might be wondering that if it is so clear and if it is so simple, then why do we tolerate these special laws? Why don't we strike them down? Why don't we do anything about it? Now, I have an answer to that. It's my answer. You can disagree and you can do that. These laws are enforced and enacted by an acceptance on our part. We are also at fault as civil society members. And I'm counting every institution, including the judiciary also. We accept their logic first, and then we scrutinize them. We accept the necessity of a UAPA, and then we try to scrutinize it. And therefore, we fail in seeing these very clear and stark abuses that are there for everyone to see. And if one looks at the judgments of the Supreme Court in Kartar Singh, which was a decision upholding validity of the TADA, certain sections of the TADA, as well as PUCL, which was a similar decision upholding provisions of the POTA, you will see what I mean. These are judgments where the Supreme Court has accepted the logic of terror being different. It has accepted the logic of the government that it needs a special law, that it needs special procedures. And therefore, it has accepted the logic that violation of rights for terror accused is okay. It is fine because the nature of the beast is such that we need to violate these rights. And essentially, it is that, and I'm refusing to sugarcoat it as anything else. Kartar Singh is, as a judgment, if you look at the first half of that judgment, it is only talking about what grave a challenge terror is and how terror must be tackled at an international level and a national level. There can be no judicial scrutiny with principles of 2120 in mind if one accepts the logic of the act first and then proceeds to scrutinize them. That is an abdication of what is to be, let's say, a strict scrutiny standard or even a manifest arbitrariness standard. It is quite funny that if one looks at Kartar Singh, the judges seem to concede the possibility of custodial torture and forced confessions, but still disregard that ground as a ground to strike down the offending provisions of that particular statute, right? I think that if one proceeds by this logic, that you accept what the government has to say and then you try to scrutinize these laws, then you're not getting anywhere. One has to ask at a base principle level, why? Why do we need these special laws in the first place? What do they do that the IPC cannot do? And if you look at this question honestly, then you will find that the only way in which these laws are different is that they allow the state and they allow the police to abuse and violate due process rights rampantly, and it is what it is built in the law as well, right? So we need to question why special laws need to exist in the first place, right? Again, I'm not saying the IPC is perfect. I'm not saying the CRPC is perfect, but that does not mean that you altogether need a special statute. I will end at a theoretical level, right? And let me go into some legal theory for a brief while. Now, in law, there is a school of jurisprudence called the modern natural law theory, right, which looks at the law as a social aim and not just as an abstract entity, but something that is created to guide society towards a particular thing, right? And I'm saying this in a very crude fashion. It's a much more detailed and nuanced theory. One of their great proponents was this philosopher and legal scholar called Professor Lon Fuller of the 20th century, taught at Harvard Law School for a long period of time, is quite famous in legal philosophy circles. Professor Lon Fuller said that for a legal system to function with this aim in mind, that it has a particular aim and it wants to guide society towards a particular aim, it must generally have certain minimal content of morality. And in this morality, he did not mean morality in a sense that we might generally think of it, in a sense of what is right and wrong substantively. But he put that moral principle on a very procedural sense, right? And he said that each legal system must have certain procedural safeguards that it must adhere to. These are there in our Indian legal system also. If you look at Article 20, what is it? It is procedural safeguards that are so important that they are put in Part 3 of the Constitution itself, not left to a statute to enforce, right? Now, one of the principles that Professor Lon Fuller identified was generality of laws. And he said that if all laws are general, that is, that they apply to all situations, right? Even if you have evil ends and evil motives, you will not be able to achieve those evil motives because the generality of laws will stop you. You cannot treat every accused in a very, very horrible manner. And therefore, if you have the same general rule for how each accused is to be treated, you won't be able to treat any accused horribly on a relative scale. Right? That's the point that he's trying to make. If you have general laws, they will lead you more or less towards fairness than specific laws. If you violate generality, it becomes very easy to write down an evil law and say it will apply only to a specific situation or only to a specific class of people. In India, what we have done, what our legal system has done, is the reverse of what Fuller has said. We have abandoned generality in criminal law. We have general statutes, we still use them, but wherever we want to abuse rights, wherever we want to truncate rights, the first tool is to abandon and destroy generality. Special laws are a destruction of general criminal laws. They are a destruction of generality in criminal laws. And because they are special and they proceed on that logic of being special, which we buy into and we swallow without asking any question, we see the kind of abuse that these special laws can with impunity achieve, right? And that's what has happened. So in my view, the criminal justice system and due process rights, if one looks at it in the present context, the greatest challenge is the proliferation of special criminal statutes across the country, which are being used with impunity to abuse and to violate rights of the accused. They are given to us on a promise of security, that they will make our lives more secure, and they're given to us selling us a vision of who they will be used against. In the 1980s, the vision of a potential terrorist was very different. Today, it's very different. Ultimately, it is used against all sorts of people. It is being used against academicians, academics, students, activists, anyone, right? Ultimately, it ends up strengthening the hand of the state. I forget who said it, and I'm sorry for that, but I think it was someone from the US who said that those who abandon liberty at the altar of security end up losing both liberty as well as security. Or he said, don't deserve either liberty or security. And I think that is what we have, the situation that we find ourselves in is today. So I think with that, I'll conclude. I'm very happy to take questions and make any points clearer if anyone wants to, but I won't take more time, and I'll stop there. Thank you very much again for having me here this evening.
Thank you. Thank you so much, Kunal. That was a very, very crisp presentation, touching upon the crux of what's plaguing the criminal justice system today, which is the creation of due process law, which are designed for abuse, who from the very inception are, these laws are violative of every constitutional tenet and every procedural safeguard in our penal laws. Thank you so much. We have a few questions that we've shared with you on personal chat.
Okay.
Perhaps I haven't sent yourself questions yet, Kunal. There you go.
Thank you.
So perhaps you could take them once Rebecca ma'am answered hers, by which time we'll have time to go through them.
Yeah.
Ma'am, would you like to go? We haven't unmuted you. Just give us a minute.
I'll mute myself.
Mute you. Yeah.
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 Okay. Is the presence of a lawyer mandatory during interrogation? Is a question I've been asked to answer. So even before Section 41D came into the statute book, we had judgments of the Supreme Court in Nandini Satpathy and many other judgments thereafter, which essentially endorsed the proposition that when an accused person is being interrogated, at least for a short period of time, he should have access to a lawyer. So in places like Delhi, we routinely make applications and they are routinely allowed. You cannot be present in the interrogation room, but you can be present at a distance. And for a short period during the day, you have the right to meet the accused person who is otherwise in police custody. I hope that satisfies you. Do I take the next question or do I hand it over to Kunal?
Yes, ma'am, you can take the next question.
I can take the next question. So the next question is that the magistrate granted custody in the Thoothukudi case, custodial death of 2 men who were arrested for keeping their shops open a few minutes post-curfew. Do you think that decision was right? Now, I'm not here to examine the correctness or otherwise of decisions made in particular cases. But the larger point I made is that very often magistrates do not examine the material placed before them. They do not even examine whether the accused is being prosecuted or charged for bailable or non-bailable offenses. Whether the offense as laid out in the FIR makes any sense at all. Whether the argument being raised by the defense that even on a plain reading of the FIR, no offense is made out and it doesn't satisfy the ingredients of the offense. These are things that the magistrate must consider. Beyond, of course, as I said, looking into case diaries and looking at the pace and the manner of investigation of the case. So coming to this question, it looks as though the remand was granted mechanically simply because two men decided to keep their shops open a few minutes post-curfew. Now, this is exactly the kind of situation that magistrates must not encourage the police to do. And this is exactly where they should come down heavily and say, we will not grant extension of custody and we will release them on bail. Again, I don't know the exact facts and circumstances of the case, but on a reading of your question, this is my answer. The next question to me is a little different. Amendments in rape laws providing harsh punishments and strict timelines to complete trial. Your views on the right to speedy justice vis-a-vis right to a fair trial. Very, very interesting question. I have been a long time opponent of fast track courts. I believe fast track courts are a bit of a gimmick and people buy into this quite easily. everything in this country has now become fast-tracked, and everything goes to a fast-track court, which begs the question, which are the matters that go to ordinary courts? Which are the matters which don't allow, which don't justify fast-tracking, right? So if an accused is in custody, or if there's a criminal matter, why are some cases treated for fast tracking, and why are other cases given to normal courts? If you look at the situation in some of the major cities in this country, a lot of emphasis is given to matters pertaining to the Prevention of Corruption Act and the PMLA Act. I wonder whether corruption is more serious an offense than offenses against the human body. And I wonder why this kind of importance is given to corruption. Is it because there is a political angle to it? Is it because you want to have some people put away? What is the reason why we are so obsessed about corruption? Not that you shouldn't be, but what is the reason why so much importance is given to offenses which are tried under the Prevention of Corruption Act and the PMLA Act? Whereas offenses which may affect the human body, like murder, are allowed to remain on the cause list of a court for 10, 12, 14 years, sometimes with the accused still in custody. Why is it that other cases, or cases under UAPA, start with so much fanfare, and then somewhere down the line, the prosecution loses interest? But the consequence of their loss of interest is felt by and borne by the accused who remains in custody. Nobody will touch his case, nobody will grant him bail. He will remain in custody for years on end. And after 12 years, you've heard that he is acquitted because the prosecution has not been able to establish its case. So fast tracking is not something I particularly support. I have looked at the way fast track courts function, and I do not believe that you can make these kind of distinctions. In the end, every court is a fast track court, right? So which is a slow track court? I don't understand. So these are all, as I said, these are gimmicks that is meant to appease the general public. When a particular case attains prominence or notoriety, then immediately the government announces that a fast track court will be set up. Speedy justice vis-a-vis right to a fair trial. We've had cases remarkably, both under the amended rape law as well as under POCSO, where courts have handed out sentences in 7 days, 10 days, 15 days, 2 months. This is the kind of travesty that should never, never take place. Please allow accused persons to contest the case with as much robustness that is available at their command. Allow their counsels to examine case details. It takes time. These procedures cannot be, you're sometimes dealing with voluminous documents. In some of the Delhi riot cases, documents are charge sheets and documents up to 2,000 pages. You cannot expect counsels to read them, formulate a defense, finish cross-examination, produce defense witnesses, etc. in 7 days, 14 days, 21 days. That is not going to happen. And if you've done that, it has only ended in that judgment being overturned by a superior court. I will therefore answer that question by saying that every trial should be finished within a reasonable time period. By reasonable, I have no definition of reasonable here, but by reasonable, I don't mean 10 years or 12 years. I mean within at least it should be made, we must be made aware of the fact that every date was a productive date, that short dates were given, witnesses were examined, witnesses were cross-examined, and that you did not endlessly keep people in custody. So never speedy justice at the cost of a fair trial is my answer to your, because then that's not justice. Then you've only completed a formality. You have not really substantively looked into the rights of accused persons. Next question, can we please know the name of judgments of Delhi High Court that you quoted? Of course you can. unfortunately, I don't think they're reported because we are now in this peculiar space of virtual hearings. The judgment with respect to rights of investigating officers to get documents that they believe exist is a judgment in bail application number 913 of 2020. The title of the case is Navendu Babbar versus State of NCT of Delhi. It was pronounced on 18th June 2020. Likewise, the other judgment where the court said it was no part of its duty to send messages to society, that it was only supposed to look at the evidence collected and the facts placed before it. Judgment in bail application number 945 of 2020, decided on 29th May 2020, again by the Delhi High Court. Title of the case, Firoz Khan versus State NCT of Delhi. Is that it, or do I have more questions? Yes. Yes, there's a question for me. Thank you very much for stressing upon the importance of due process and the ways in which they are subverted by the state. I would like you to comment upon two kinds of slippages in the execution of criminal justice. One is the disparity in which lower courts interpret the statute, as in sedition cases, for instance, or pass orders of remand or bail, which often seems to be leaning towards the prosecution overriding the rights of the accused, while the higher courts often seem to give more consideration to the latter. The other is the way in which courts seem to be swayed by the public, read dominant views of society, jeopardizing the minorities and vulnerable communities like tribals and Dalits. So there are like multiple questions in one question. I'll try and answer them. Yes, you know, at first blush, I might be tempted to agree with you that lower courts tend to interpret the statute in a very conservative way, and these errors are then corrected in superior courts. That is probably true, but I have experience of the reverse as well, and I will like to highlight that in many cases. Including the death case that I referred to in the earlier part of my address, the subordinate judiciary scrupulously followed the law and insisted on compliance of procedural law as laid down by the various jail manuals and various judgments of the Supreme Court in the period between mercy and execution of death warrant. So it was a case where the subordinate judiciary was scrupulously following the law. I'm not entirely sure whether the High Court and the Supreme Court gave that kind of leeway in that case. In cases of sedition, while we may be tempted to say that the higher courts by and large give more liberal interpretations. I have had I've had a different experience in some cases where I felt that the lower courts have been also compelled to draw attention or to ask the prosecutor all the right questions as to how sedition is applied, and in many cases they've granted bail. Of course, some of these experiences may vary from people to people. I do see cases in other parts of the country where the subordinate court has absolutely refused to apply its mind to the law relating to sedition, and then it has subsequently been corrected in higher courts. With respect to courts swaying to public opinion and sometimes jeopardizing the interests of minorities and vulnerable communities, yes, that is absolutely right. What I would like to say in response to this question is, and it's really what the Delhi High, and that's the reason why I read out that portion of the Delhi High Court order. I think somewhere all of us need to understand what is the job of courts. And I repeatedly say this in arguments, that it doesn't matter who you're representing. You can accuse that person of the most heinous crimes, but it is the job of the court to assess the evidence, to marshal the evidence against that person and find out whether, if all of what the prosecution is saying has been established on paper, the public narrative is of no consequence. On paper, on the record of the case, has the prosecution established its case, or does it remain in the realm of a fairy tale, which it first brought out when it was introducing the case to the media and to the general public with much fanfare. Now, if courts were to do that, we perhaps would not find this public versus individual argument being brought out in this manner. Unfortunately, what happens is, and courts are not immune to public pressure. They, I imagine, read newspapers, and I imagine see some of the cacophonic debates on television. And perhaps somewhere it kind of, there is this hydraulic pressure which is exercised on them. They're human after all. Our endeavor as a system, both as lawyers as well as people on the other side, should be not to get influenced by that. Ultimately, you have to go by the record of the case. And if the record of the case suggests either that people guilty of the crime have deliberately been let off, as had happened in the Hashimpura case, or that if people who are in custody, the record suggests that there is not a shred of material against them, credible legal material against them, then this prejudice must not set in. I'm afraid I cannot say that that is the way cases and law are examined always by courts. I'm afraid prejudice does play a large role, and therefore there is great merit in what you are alleging in this question. The next, is this to me? Yes. This question is to both panelists, perhaps. Yeah, for the common man in India, the local magistrate or the SHO is the sovereign. Now, who will explain the problems with due process violating acts to them? What tools do lawyers at a district court in a small town have at their disposal in an environment where authorities are apathetic to conditions of justice? I understand why this question is being asked, and who is going to indeed explain due process to an SHO? You're absolutely right. And as you go into the interiors of this country, I've known of magistrates or of sessions judges who for a long time did not know of the Criminal Law Amendment Act of 2013, which made those drastic changes to laws relating to sexual assault. Even now, are unfamiliar with procedural law or laws of evidence, for example, the certification under Section 65B. And I've often asked lawyers, what does this mean? What is the certification all about? So as the advantage that bigger cities have is that perhaps, and particularly places like Delhi, because we are so close to the High Court and the Supreme Court, so everybody gets to know the law. But you're absolutely right. Even in Delhi, who's going to explain to the SHO what is due process? I wish I had an answer to that question. And second, as you go into the interiors of the country, what tools do lawyers, what possible tools can lawyers employ at the district level to bring out the apathy of the system? I will answer that. I've always told fellow lawyers, colleagues who are junior to me, younger lawyers, that the only way we can get past these kind of cases is to contest, challenge, and contest. There is no other way. You can't be nice people in court. And you have to contest everything. So if somebody is asking for remand, you contest, move an application opposing remand. If somebody is asking you for voice samples, move an application opposing remand, at least give a reason why that is not going to, why you do not want your client to be subjected to it, even if the law is against you at this point in time. If you are asked, if police custody is sought for, oppose it. So I think what I encourage practitioners to do is to make written opposition, not just oral opposition, so that the record of the case will show that at that point in time, you had opposed it for these reasons. And I'll end this by giving the example of a client of mine whose trial I did, who got acquitted after 12 years of incarceration. At a time when he was not represented by any lawyer, he opposed the test identification parade application moved by the prosecution himself, and and insisted that the court write down his opposition in her order. And what did he say? He said, I have been shown to witnesses. And he described the witness. He didn't know his name, but he described the witness when he responded to that notice given to him. When that witness came to court, that description was near perfect. And one of the reasons he was acquitted was that application, that response to application he had moved to the first instance when he wasn't even represented by a lawyer. So all of these stages, and there's so much that qualifies, so much the prosecution does that will compel you to give a response. You should be compelled to give a response, preferably in writing. Have conversations with your client. It is their story which you are seeking to put on the record of the case. It is their experience with the police prior to arrest, after arrest, which you want a court to see. Therefore, write it down, contest these through written responses. And one day when you're doing the trial of the case or when you're cross-examining the witness, pick up those responses and you will see the connections. I think that's it. Thanks.
Thank you so much, ma'am. I don't know if there are more, but we're going to go to Kunal now. And yes, if there are more, we just put that to both the panelists. Thank you. Kunal, do you want to take your question?
Can you hear me?
Yes.
Okay. All right. So the first question is, what is the difference between due process and process established by law? Only the latter is mentioned in the Constitution. Yes, you're right. If you look at Article 21, the bare text, it does not say due process of law. My entire argument is limited to the interpretation that has been given to it in scores and a catena of Supreme Court decisions. If one looks at, let's say, Menaka Gandhi, subsequently, how we have interpreted the Article 21 safeguard, that procedure cannot be frivolous or vexatious or arbitrary, must be reasonable, that constitutional provisions are not, let's say, airtight silos, but can draw from each other. Even under that standard, forget due process for a while. We are not talking about the American due process standard. Let's say if it is different, though I would also say that it is not so different anymore with this expanded understanding of Article 21. These special laws will not stand the test. If an honest and rigorous application of these tests, let's say the test of manifest arbitrariness or strict scrutiny, is applied to these statutes and the difference they create, then it's very different. It's very difficult to say that these laws might survive. For example, look at one of the challenges in Kartar Singh. Now, in Kartar Singh, the Tada had created this category of special courts, right? Now, ultimately, those special courts never became really that special. There were sessions court judges who were given additional charge as Tada special court judges. So they would sit as a special judge when hearing a Tada case. But one of the challenges that was made was on this. And the accused said that there is no necessity really to establish a special court. I don't want to be tried by a special court. I want to be tried by an ordinary sessions court. What you see the Supreme Court doing there is very peculiar. It seems that the Supreme Court is weighing two rights against each other, that of a fair trial and that of a speedy trial, right? And it's saying how ordinary courts are so burdened that you need a special court in order to give quick justice. Now, the question is very simple. It's trickery really, that is what is happening. Both these rights are rights of the accused, right? They are not rights of the state. And the state cannot pass a law which says that you have to choose one right over the other. Either give up your fair trial or give up your speedy trial. That's dishonest, right? So even if you apply, let's say, the manifest arbitrariness standard there, right? And you apply that standard correctly to scrutinize that provision that should have been struck down, right? So that's my limited point. I'm not saying that we have the due process exactly of the US constitutional law in India, but even under the Article 21 jurisprudence, I would say that the point would remain. On the second question, even if there is a guilty plea, the judge won't look into merits, right? Now, if you look at the provisions of the CRPC, especially section 229, 241, 254, 252, then you can see that even if the plea is changed during trial, a judge need not accept it. He can still insist on evidence being presented and the case continuing. In fact, there's a case also which is State of Maharashtra versus Sukhdev Singh, 1992, where the Supreme Court has said that the judge is not bound to accept a change of plea. He can still continue with the evidence being recorded. Because, of course, a criminal trial is an act of state. It is something that cannot be settled in a similar way that a civil case could be by a change of plea midway, etc., or a compromise with midway, etc. Right? But what is happening in terror trials a lot of times, as you will see, is that in a lot of these cases, that is not what happens. It is that the plea is changed and the case moves very quickly towards the stage of sentencing. What also happens a lot of times is that the plea is changed and then just for formality's sake, evidence is recorded and some kind of formal cross-examination of the remaining witnesses is done, and the case is very quickly concluded. So yes, the judge has the authority to not truncate the trial. Mostly, however, what is happening in these cases, and one can look at several cases like this. In Bangalore, we've had this in the Chinnaswamy blast case, that you can just Google and see as well, that this is what is really happening. The third question was the common one, and I completely agree. My limited experience of practice in trial courts in Bangalore and in Karnataka, I completely agree with what Rebecca was saying, that you might be, as a defense counsel, in a very unfavorable position where the judge is batting for the prosecution and the prosecutor is relentless and the bar is against you, etc. I would say that you have to, at every step of the way, insist on a challenge being made to everything that is being tried to be done to your client. And it can get embarrassing. You can be under a lot of pressure to not do it. But I would say that the only way across it is through it. And I agree with Rebecca that everything should be recorded as far as possible in writing. So this lawyer, Dr. Yug Mohit Chaudhary, also says that you should keep applications prepared when you walk into court and never shy away from filing them. Create that record, create that paper trail that you oppose certain things, you opposed remand, you opposed a certain order that was being sought by the prosecution, etc., etc. So my answer is also similar. I would agree with what Rebecca was saying. To the next question, the question is, if we reject the logic of necessity of special laws, where do we look for an alternate logic of criminal law? Because it seems like many political systems seem to accept special legislation for terrorism or other such issues. I completely believe that criminal justice and criminal policy are political issues. And these are issues that are decided by what is the political situation in a particular society or in a particular legal system. We need to be aware that arguments that are made on justice and necessity to push these laws through have a very dark and hidden underbelly, which we are not patient really to analyze. So we accept the logic of national security, we accept the logic of tough laws, but we do not take time to see how these laws are exactly enacting that toughness. What is it exactly that they're tweaking? So my point really is that we must be cognizant of what is being done in the name of security, in the name of, let's say, protecting children, in the name of terror, right? And if we really, and at all points of time, we must be ready to honestly scrutinize this rationale. And we must be ready to call it out when we do not find that these laws are serving their purpose, or we find that these laws are too mischievous to be allowed under a constitutional framework, we must not be cowed down by the fact that this logic of special laws exists against us. You have to still call it out. You have to say that these special laws are unfair. You have to say that these special laws are unconstitutional. And that's what you might begin by, right? In fact, other countries like the UK have had a history of trying to enact anti-terror statutes as well, and a very colorful history of litigation with regard to those statutes, right? Where sometimes they have been struck down on precisely the kind of things that our judges never really ask, but their judges do, right? So it's not that difficult to unravel what this logic also is. Uh, Next question is, thank you for I would like to comment on the kind of conflict that law like UAPA throws to the federal structure, as in the recent tiff between the NIA and the Maharashtra government in the Bhima Koregaon case, where the central agency literally hijacked the investigation from the state government. Do such laws infringe upon the division of power? That's a very important question, where you're talking about the federal structure and how NIA and special laws like terror laws enact. We had a very interesting litigation here in Karnataka, where an RSS official was murdered in broad daylight on Commercial Street in Bangalore. And one would say that it is a murder case, and murders happen in Bangalore, especially. They do take place. But for some reason, that case was taken over by the NIA. And it was challenged in the Karnataka High Court. The Karnataka High Court, a single judge bench order, struck the NIA's taking over the investigation down. It was appealed to a division bench where it was stayed and finally upheld. Right? Now the question is this: is it a murder or not? And again, this really highlights this idea of looking at an offense as a special offense and a general offense. Right? Now, law and order and police are state subjects under the Constitution. Right? Criminal procedure is a concurrent subject under the Constitution. Under our constitutional structure and federal structure, states are fully autonomous in providing for and maintaining law and order. Look at the recent NIA amendments, right? So I can still accept the logic that attacks on India as a country, let's say, can be taken over by the central government. Let's say, for argument's sake, I accept that. So an attack on an atomic power facility is something that the NIA can investigate. An attack on an airport, which is a federal institution, is something that the NIA can take. Look at the new NIA amendment that has happened. It allows the NIA to take on investigation into trafficking of people, right? Into offenses committed with the use of firearms and explosives. These need not be terror offenses. These can be ordinary offenses that a state is fully capable of investigating. In Bhima Koregaon itself, it was a state investigation that was taken over by the NIA when it became quite clear that something was going to happen in court, right? And this is again tying back to what I say when I say that the criminal justice process is political, right? Now, how have we ended up in a situation like this? By conceding the logic of the necessity of an NIA and the necessity of a UAPA. That is what has led us to this place, where now you're seeing that an ordinary criminal law can be prosecuted as an offense against the federal government as a terror offense. Same thing is happening in Delhi, where anti-CAA protesters are being rounded up under the UAPA. So we've led ourselves into this kind of situation. I know it's not a satisfactory answer, but right now it's the best that I can do. How does having reverse onus clauses for death penalty offenses affect the due process rights in death penalty cases? Okay, so this is a big one. It's a long answer. The death penalty can be awarded. However, the Supreme Court has time and again said that there needs to be a kind of perfect certainty before awarding the death sentence. It's a ground that is often taken in Section 366 references and confirmations also by lawyers to say that because there might be circumstantial evidence, a benefit might be given and it might be commuted to life.
So we use all of these arguments, and these arguments they have their place. One can say that a conviction can occur now and can occur using a reverse onus clause. And one, technically speaking, I would say that it is technically a valid sentence, right? Nothing prohibits you from passing a sentence of death, which is achieved by using such legal means. And reverse onus clauses are legal means that are enacted in statutes, right? Here we also see the difference between the stage of conviction and the stage of sentencing, right? To any judge, to any reasonable judge, this would be quite apparent that though you may use a presumption or you may use a reverse onus clause to convict, it might be slightly unfair, and there is always that scope of doubt that exists, which should not lead you to sentencing them to death. Can it happen? Yes, it can, right? Can it be used as a ground in subsequent rounds, let's say, of litigation that might happen? Yes, of course it can be. But technically, I would say that there is no bar on such a sentence being passed. Right. Next question is preventive detention laws are part of the Indian Constitution and have been inserted in Part 3. It is unheard of in any democratic constitution across the world. Yet none criticizes the very Article 22 and laws like NSA, TADA, POTA, UAPA, MISA are the children of Article 22. Why don't you initiate a campaign for abolition of the second part of Article 22 rather than criticize the law, right? You are right. If one looks at A.K. Gopalan versus State of Madras as well, preventive detention has been upheld. Preventive detention is also a kind of special statute. I agree with you, especially when it comes under something like MISA or something like the NSA. So I am in agreement with you that there should not be preventive detention of the nature that is allowed under these particular statutes. I think that again, it's slightly okay. So Article 22 Part 2 is something that you have identified this problem with. I think that even maintaining Article 22 Part 2, there are certain excesses that these laws allow for that can still be struck down. You don't need to attack Article 22 Part 2 directly in order to achieve this particular aim. If A.K. Gopalan were being decided again today, would we reach the same conclusion now with our Article 21-22 jurisprudence having developed? Well, it's difficult to say, but in an ordinary situation, perhaps not, right? So, yeah, that would be my short response to your question. On your idea of special laws being able to survive because they enjoy public or judicial acceptance, isn't it that public acceptance is given to the mandate of special law and not to each specific provision, right? So can we very clearly say that those abusive special laws are being backed by the state? That's a good point. My entire argument is this, that public support is garnered on an abstract idea of national security. It is garnered on an abstract idea of terror. We are not shown the details of how the UAPA is going to work. We are not told about reverse onus clauses and how they work, and about custodial extensions of custody and denial of bail. We are ready, and generally the public opinion is framed in a very abstract sense of, yes, we need a tougher law. What happens once that law comes in? Very few people would have the patience to really sit and look at what the law is actually doing. And this is somewhere where the legal fraternity, civil society, etc., has also not been able to disseminate this information clearly. To say that your goal of national security is being achieved by rotten ends, right, is something that needs to be disseminated. So you're right, the public doesn't know. Probably didn't bother to find out. They accepted that the government is doing something that is right. Another thing is that a lot of the members of the public did not ever think that they will be on the receiving end of this law. One does not imagine, especially if you come from, let's say, a particular background of privilege in terms of religion, in terms of caste, in terms of class, you never think that you are going to be a terror accused. And therefore, this entire discussion seems to be in the abstract. Right? So in such a case, you'd never know. You don't really, but I agree, you have not thought about it. But the point is to think about it. Right? All right. So those are the questions that I had.
Yes, thank you. Thank you so much, Kunal. We have many more questions, and we're not going to be able to put them all. But I just have one last question to each of our panelists. Perhaps Kunal could go first. Picking up from one of the points that Rebecca was making about the period of remand of 90 days under the CRPC and 180, and that could get extended up to 180 under special laws like the UAPA. Through your work, could you tell us what the situation is in other countries with respect to the period of remand?
Right. Yeah. Now, in the United Kingdom, several decades ago, this was when the IRA insurgency was at its peak. The British government had enacted a statute which allowed for 7 days custody before being produced in court. Right? And that was struck down by the House of Lords as being too draconian for a country like the UK. So, of course, the situation has changed with after 9/11, right? But and in America, the situation is completely different because there they have this black hole called Guantanamo Bay, where now they are establishing geriatric facilities because people have been kept for decades there and have just grown really old, which is tragic. But if you're a US citizen, right, then of course the situation might be very different for you. I would say that a period of 180 days and 180 days further being extended if there is an application being filed and there is reason to say that there needs to be some more time that is given is absolutely draconian. It is now in bail jurisprudence, and I'm sure Rebecca will add on to this as well. The basic principle is that pre-trial detention can never be punishment. It can never be meant, it is not meant to substitute incarceration and punishment. It is only given when it is necessary to be given. Otherwise, there is a threat of absconding or tampering of witnesses, etc., or the commission of more crimes. What 180 days, 6 months essentially means is that it is punishing you. Right? And let's say even what happens immediately after the charge sheet is filed is that in these cases, such as the UAPA cases, you don't get bail throughout the trial. Right? You have situations where people are being released after 23 years in custody, after having been acquitted. And this was just some months ago, a Kashmiri man who was released, finally acquitted by the Rajasthan High Court after 23 years in custody. Right? And what remains then of a presumption of innocence, of not punishing people, of due process in such a situation like this? And cases like this are happening all across the country. Right? So it's something that needs to really be looked into and reevaluated. It's incompatible with any civilized jurisprudence around rights. I'll let Rebecca add on.
Yes. Well, in the context of UAP and how draconian this is, and how by and large, the public, including lawyers, actually don't know the extent of its application and what it can do to fundamentals of criminal law. For example, if you were to see the section pertaining to bail under the UAP, it is 43D5. Yeah. What does it require? General law requires that you make out a case, and the sessions court will, either the magistrate, depending on the offense, or the sessions court will determine whether you are entitled to a release or not, or if not, you go to the High Court because it's a concurrent jurisdiction. Under the UAPA, it has become, and indeed under many other special laws like MACOCA, like the NDPS Act, etc. What is the provision? And it's just this mindless copy paste in all of these special laws. You have the same provisions coming up again and again and again. It says that every accused person shall not be released on bail if the court, on a perusal of the case diary or the report made under section 173 of the code, is of the opinion that there are reasonable grounds for believing that the accusation against such person is prima facie true. Imagine how difficult it is for a court. If the court was to come to a conclusion that a person is entitled to bail, the court must give a certification that on examination of the case diary or the charge sheet, it appears that there is no prima facie case against the accused person. Why go into the stage of charge? Because that determination has been made by the bail court. And if at the stage of charge, an accused is to be charged for offenses under the UAPA, what happens to the earlier determination given by the bail court? And can such a determination be made? Likewise, if you look at 43D itself, the extension of time, the proviso to subsection 2 is so draconian. A prosecutor moves an application, a report, and says, these are the reasons for extension of time from 90 to 180 days. We are now reached the stage where we are arguing before court, you have to give us notice. Let us at least respond to the prosecutor's application, because it's my detention which is sought to be extended. And the state is fighting us tooth and nail. So while the earlier periods of remand under UAPA are for 30 days at a time, the maximum of 30 days, the tranches from 15 has increased to 30. You can possibly extend from 90 to 180 days in one shot. What are the rights? Whose rights are you trying to protect? The rights of the state or the rights of the individual? So this is the nature of this is the nature of the beast. And I think many people, it's fashionable to say the UAPA has been invoked, but what does it mean to an accused person is something that you understand only if that accused person is going through the process of a UAPA trial, or if you are regular practitioners, you realize it. Likewise, under the NIA Act, look at the schedule and look at the kind of offenses they have brought into the schedule. It is possible for the NIA or a state investigating agency to invoke any of those statutes, including the IPC, including free speech matters, and make it an NIA triable offense. You've suddenly elevated and escalated in normal, it's okay, you can charge me under or anybody under 124A, and you prosecute, you do whatever you have to, eventually somebody gets bail, and that's fine. There's a regular process. But the minute you tag it in this manner, and the minute you give it you preface it with these kind of legislations, you are automatically playing into the rights of an accused person. It doesn't matter whether you ultimately get acquitted. It doesn't even matter whether you ultimately get discharged, if that ever happens. But the minute agencies like these come into prosecutions, and as Kunal said, it is arguable, we're not conceding that position, but it's arguable that if there is a direct attack on the state, you invoke these legislations. But why must you enter into ordinary criminal law when ordinary criminal law has made provision for these offenses? In an interesting argument which took place recently, an attempt was being made by the prosecutor to suggest that an offense under Section 13 of the UAPA Act, which is punishable with a maximum of 7 years, unlawful activity, is more serious than the offense of murder. What kind of space are we occupying at the moment? What happens when people are tagged with these legislations? And that's the larger point, which I think Kunal was trying to make and which I am trying to make. The danger is not that you're being prosecuted under a Section 13 of the UAPA. The danger is the implications of the invocation of this act. Implications to ordinary criminal jurisprudence, to ordinary protections granted under the Code of Criminal Procedure, and where it takes an accused person, where you pretty much tell them, sit quiet, sit tight, There is no way you're getting bail. And it's entirely possible, it's almost certain, that you will be in detention for a period of 180 days. Although, even this legislation imposes checks and balances, but who's looking at them?
Correct.
You've normalized it to such an extent that the minute you invoke UAPA, you tell your client it's 180. That's really sad. That's really sad, because you essentially, courts and the judicial process have abdicated their functions. They are not looking into, they're not even asking basic questions. Why is the UAPA applying in this case? So somebody gave a speech, big deal, you didn't like it, never mind, so what? Many people say many things, I don't like it. I don't have to go and invoke UAPA. How is the state affected by these offenses? How is the sovereignty of the country affected by these offenses? Assuming they're even offenses. How do you invoke 13? How do you invoke 15 without acts of violence? So these are preliminary questions and basic questions which need to be asked. And one day we will suffer very, very badly as a community, as a society, if these questions are not asked and if action is not taken.
Ma'am, thank you so much. I was about to ask you the question about what your response would be to having special laws as opposed to general laws, picking up from what Kunal had said. Yeah, you've just answered that. So thank you so much. We have a lot of other questions, but we're not going to take them, unfortunately. We've also received a lot of appreciation for this webinar, saying it was very insightful and valuable. So we're very glad that you were with us to initiate this very, very urgent and important conversation. And hopefully we can all come together more times in the future to take this forward, because it's really very, very important given the circumstances we live in. So once again, my heartfelt gratitude to both of you for joining us this evening. Thanks also to all the participants who enthusiastically registered and joined us. So thank you so much, both Rebecca and Kunal. Thank you.
Thank you, Purna. Thank you very much.